Good afternoon. Thank you for coming to UCL. My name is John Martin, and I'm Professor of Cardiovascular Medicine. But I'm not here as a cardiologist. I'm here simply to chair the lecture this afternoon, which will be given by Dr. Myriam Hunter-Henin, who is a senior lecturer in law here at University College. And I see from her CV that she has worked also in the Sorbonne in Paris, and you are indeed French.
I am.
So, we're both citizens of the European Union. And she's going to talk about something which is extremely important for the development of human society, that for me brings together the past, the present, and the future. It's religious diversity and social harmony.
Thank you. Good afternoon. Many thanks, John, for the kind introduction, and thanks to all for coming to this lecture today on social harmony and religious diversity. I'd like to also express my gratitude to the organizers of the UCL Lunch Hour series, without whom, of course, we wouldn't be here today. Social harmony and religious diversity. If you're working in or are fond of political theory and philosophy, this is a topic that you're probably quite familiar with. Political theorists and philosophers have for a long time debated over how religious arguments can feed into political debate and therefore contribute to social harmony. With the Charlie Hebdo attacks recently in Paris, which came after I had proposed this topic for the lecture, the interconnections between freedom of expression, political debate, and respect for religious beliefs have come to be at the forefront again. In the Charlie Hebdo situation, the perspective is reversed. The question is no longer how religious arguments can feed into political debate, but whether political debate should exclude comments, drawings that are insulting to religious believers, religious communities, especially the argument is made if these religious communities are already in a politically, socially disadvantaged position. But the relationships between social harmony and religious diversity go beyond these crucial reflections on freedom of expression and its scope. And today, I'd like to look at more generally how courts have addressed these relationships. Courts have had to consider the issue in varied situations. At times, it is positions reached through social consensus that have been challenged before the courts. Non-believers have thus criticized the opening of council meetings by prayers in Bideford Town Council in Devon, or the mandatory presence of crucifixes in Italian state school classrooms. At other times, it is minority religious practices or exemption requests based on religious grounds that have been denied by judges for the sake of protecting social harmony. And here one might quote the practice of wearing the burqa or niqab that has been banned in France for the sake of harmonious life together. In England, religious beliefs clashing with national equality policies have given rise to litigation in the workplace or in respect of hotel, adoption, fostering services. In all of these instances, common values of equality have been held to prevail over individual rights based on religious beliefs. From this litigation, one is left to wonder, when then is religious diversity beneficial to social harmony? When can individuals who do not share certain common values legitimately be restricted in expressing their dissenting beliefs? Should we have common values at all? If so, should common values be redefined in order to be more inclusive of dissenters? In what circumstances should individual rights triumph? In what situations should common values prevail? These are the sort of questions I'll be throwing at you in the course of this lecture today. To give a bit of focus, the main part of this lecture will deal with the recent European Court of Human Rights case, the SAS case, which upheld the French ban on the burqa on this basis of social harmony, or to quote the court, because the wearing of the burqa was held to breach the requirements of life together. I will then go on to consider briefly the English case of Liddell, in which a registrar employed by Islington Borough Council wished to be exempt from conducting same-sex civil partnership ceremonies. Ms. Liddell claimed that her involvement offended her Christian beliefs, but Islington Borough Council denied her request for exemption. English domestic courts then dismissed her claim that this refusal amounted to religious discrimination. The conclusion was finally upheld in Strasbourg. In 2013, the European Court of Human Rights held that the UK was entitled to prioritise a common policy of equality over the minority religious convictions of employees. Confronting these two decisions, I will argue that whereas common values wrongly, in my views, prevailed in SAS, they rightly trumped individual rights in Liddell. So let's start with the SAS case, the case relating to the French burqa ban. It may be useful to remind everyone that the burqa or niqab are forms of Islamic veiling which hide the body and the face completely, except for the hands, and for the latter for a gauze panel or slit for the eyes. What happened then in SAS? In SAS, the claimant brought a challenge before the European Court of Human Rights in Strasbourg against the 2010 French law, which banned the burqa and the niqab, or in more neutral terms, the covering of the face in all of the public sphere. Last July, on the 1st of July 2014, the Grand Chamber of the European Court held that the French burqa ban did not violate any convention rights. According to the court, the ban interfered with Article 8 of the Convention, which protects the right to privacy, including the right to choose one's appearance, as well as with Article 9, which protects the right to hold and to express religious beliefs. However, these interferences were then held to be justified under the minimum requirements of life together and proportionate in view of the so-called light sanctions attached to the ban. I disagree with the court on both counts, but today I will only focus on the first point, the suggestion that the ban was justified in order to meet the necessary requirements of living together. What did the court exactly state? In SAS, the court held that under the wide margin of appreciation recognized to France, it was able to accept that the barrier raised by a veil concealing the face could be perceived by the respondent state as breaching the requirements of life together. Such use of social harmony as a legal basis for assessing restrictions to individual rights to religious freedom is, I submit, unconvincing. The European Court itself only uses the notion with extreme caution I quote, for example, the court saying, "In view of the flexibility of the notion of living together and the resulting risk of abuse, the court must engage in a careful examination of the necessity of the impugned limitation." This uneasiness of the court towards its own legal basis is unusual and striking. Why this uneasiness? Because the concept, as the court admits, is elusive. Let's pause then and try to see what its substance could be. What could the concept of living together contain in this context of burqa bans? What is clear is what is not covered by the concept. The court states explicitly that living together, social harmony, do not refer, in the context of burqa bans, to potential threats to public security. Public security risks could not warrant a blanket ban in all public places unless there was a threat to national security. It seems that in the context of burqa bans, the requirements of living together would rather refer to the duty to engage to some degree into social interaction with fellow citizens. So wearing the full veil could be seen as breaching this duty of social interaction, in that the wearer seems to give her religious identity absolute priority over her identity as a citizen and refuse all interaction with fellow members of society. And that was the decisive factor in France as well, and that was the reason why the law was upheld by the French Constitutional Council. But I see several problems in such reasoning, and I have selected three main objections. First, empirically, it is far from established that women wearing the burqa in France do not, in fact, comply with this minimum duty of social interaction. Secondly, it is difficult to see why the social expectation of a minimum social interaction should be translated into a legal prescription. And thirdly, this reasoning contradicts the human rights framework. Let me take each objection in turn. First, the concept of living together, therefore, relies on assumptions that are not backed by empirical evidence. Those assumptions are that women who wear the burqa live as prisoners of religion, and the burqas have often been compared to prisons of cloth. The problem is that empirical research suggests, on the contrary, that women in France who decide to wear the burqa do not live as prisoners of religion. In the SAS case, the applicant, it was submitted, did not lead a recluse life. She did not systematically wear the burqa. She was happy to remove it when visiting the doctor or meeting up with friends, but wished to be allowed to wear it at times of particular religious significance during Ramadan, or when she felt the need to be at inner peace. It is therefore highly debatable whether in this particular case the applicant herself was actually in breach of the minimum requirements of living together. There is a mismatch between the conclusion reached by the court, under which the wearing of the burqa is said to breach the requirements of life together, and the analysis it carried out on the facts of the case, which seemed to have led to the opposite conclusion. Despite this concerning contradiction, I think that the court is to be praised for its careful analysis of the facts. Unlike its own prior case law, the court in SAS took great care in understanding the applicant's personal motivation for wearing the burqa and the concrete adverse effects that the ban may have on her life. It also refused blanket descriptions of the burqa as a symbol of repression against women. Of course, this minute scrutiny of the facts makes the court's sudden acceptance that France may nevertheless see the wearing of the burqa as breaching the requirements of life together all the more unexpected. All in all, the court does not adhere to the notion of living together with great enthusiasm. It warns against the risks of abuse that the notion may allow, and only endorses it in the end because of the wide discretion it's willing to grant France on this choice of society. I don't think that France should have enjoyed such a wide discretion. But in any case, even if such deference had been justified, I think that the law on the burqa should not have been upheld against the European Convention on Human Rights. Even when a broad margin of appreciation is rightly recognized to member states, it does not equate to granting them a carte blanche. Certainly, sorry for the French accent there, certainly it should not allow national parliaments to adopt coercive laws for reasons that are proved to be empirically wrong. My second objection lies in the confusion that the SAS judgment creates between social and legal norms. This is a slightly more theoretical point. The European Court in SAS suggests that the burqa is more problematic than other religious clothing because of the importance in today's societies of facial communication. Right. But why should the sociological importance of the face carry any legal force? Such alignment of legal norms on social expectations is reductive, something we also see in the Charlie Hebdo debate, actually. Of course, many have acknowledged that law is embedded in society. But the symbiotic relationships between law and society should not result in a confusion of legal with social norms. Both legal norms and social norms seek to influence behavior, social behavior, and will therefore often converge or even coincide. But this does not mean that the coercive power of the law can be justified by reference to social expectations alone. In SAS, social norms as to how to live together are endorsed by law for the sole purpose of reinforcing these social norms. It is important to note here that all of the other arguments that had been put forward by the French government in order to justify the law were rejected in forceful terms by the European Court. The European Court declared that it was not convinced by the French government's submission that the ban might also seek to protect the equality between men and women. Why? Because it is self-defeating to try to protect women's rights by forbidding autonomous decisions that they make. The court was not convinced by the French government's submission that the ban might also seek to protect women and human dignity in general. Why? Because wearing the full veil is an expression of religious and cultural diversity which contributes to the pluralism inherent in European democracies, and because there was no evidence that women wearing the burqa wanted to express any form of contempt. And finally, the court considered that the aim of public safety, as mentioned earlier, did not hold any ground. The reason for upholding the law was therefore exclusively this notion of living together. This, as I have argued, is too thin a justification for legal intervention because social norms do not have any inherent legitimacy. The reasoning is flawed since the crucial investigation as to why this social norm of uncovering the face in public should be supported by law is lacking. Moreover, this inflated role conferred on common social values, on social harmony into legal reasoning, and that will be my third objection, this inflated role is incompatible with human rights protection. Two main reasons for this incompatibility with human rights schemes. First, the reasoning adopted by the European Court of Human Rights tends to limit human rights protection to moderate practices. Of course, the more extreme religious practices are, the more ostentatious religious symbols are, the more likely it is that restrictions to their display will be deemed to be legitimate. But this legitimacy of the restrictions still needs to be established. It cannot be presumed to exist because the practice targeted is extreme. Secondly, the reasoning adopted by the European Court in SAS is concerning for human rights protection because human rights protection are then put at the mercy of majority preferences, which is the exact opposite of human rights schemes. Let me very quickly say a few words about each aspect. First, it is quite clear that the French veil ban involves a restriction of the right of an individual to express and manifest their religious beliefs. The argument whereby only extreme, unacceptable forms of Islam would fall under the prohibition would be no disclaimer, since the European Court has asserted many times that it is not up to member states to assess the legitimacy of particular religious beliefs. Indeed, religious beliefs would be, and freedoms would be seriously hampered if only moderate practices, those acceptable to the state, were covered. Similarly, the argument whereby the wearing of the burqa would not be a religious manifestation, since there is no clear religious requirement to cover one's face under Islam, is bound to fail. Regardless of the controversies in the interpretation of the authorities, the wearing of the burqa originates in scriptural authorities in the Quran, and more importantly, is subjectively strongly felt by the women who wear it as carrying a religious meaning. If the state, as the European Court reiterated in SAS, is therefore to refrain from assessing the legitimacy of particular religious symbols, how can the court then conclude that the ban on the burqa is legitimate for the sole reason that it only targets specific symbols, face covering clothing? Is the court not reintroducing distinctions between religious symbols and allowing the state to decide which ones are acceptable, the non-face covering ones, and which ones are not, those that cover the face fully? Secondly, the protection of human rights then becomes dependent on majority preferences. Insidiously, the concept of living together thus operates a radical change in legal reasoning at European human rights level, but a radical change in legal reasoning at a French level as well, domestic level. Protection of human rights must occur, if need be, even against the beliefs of the majority. Otherwise, human rights would become empty shells. Many of the court's statements in SAS actually underline this reality. I quote, for example, "A balance must be achieved which ensures the fair treatment of people from minorities and avoids any abuse of a dominant position. The court warns against the risks of passing legislation for the sake of responding to majority feelings of discomfort." In conclusion, I think that this feeling of discomfort, or even the feelings of offense provoked by the sight of women wearing the burqa, should not have been allowed to prevail over the applicant's individual rights to express her religious belief. This is not to suggest that common values should always give way to individual rights to freedom of religion. And now I'd like to say a few words on the case of Liddell, where I would argue that common values were rightly given priority over individual rights. As mentioned earlier, the case of Liddell involved conflicting views on homosexuality. Whereas Islington Borough Council wished to show its full commitment to the new sexual orientation equality policy entrenched in UK legislation, and consequently wished its employees to adhere fully to the new policy, Ms. Liddell, a registrar working for Islington Council, considered that homosexuality was a sin and wished to be spared personal involvement in the celebration of same-sex unions. She claimed that her religious convictions entitled her to be exempt from carrying out same-sex civil partnership ceremonies. As mentioned earlier, her request was denied. Her religious convictions had to give way to the sexual orientation equality policy pursued by the British state. The European Court suggests that this conclusion is justified in order to protect the rights of others, namely the rights of same-sex couples. It is not clear in what concrete way the rights of same-sex couples would have been infringed had Ms. Liddell's request been granted. The service could still have been provided for. One could still have accommodated Ms. Liddell's convictions without undermining the service provided to same-sex couples. Other registrars could have covered for her, as many had done at first. In a way, would the ceremony not have been enhanced by ensuring that the employees celebrating the partnerships were devoid of any personal hostility towards homosexuality? But even if pragmatic arrangements could have been devised in order to ensure that in practice no same-sex couple would have been deprived of access to the public service, accommodation of religious minority views hostile to homosexuality would have tainted the equality message conveyed by the British state and would have symbolically have set same-sex couples apart. It was at least possible to argue in Liddell that same-sex couples' dignity would have been eroded had the state allowed a few of its agents to be exempt from conducting same-sex civil partnership ceremonies. By contrast, it is not possible to ascertain what concrete or even symbolic rights were infringed by women wearing burqas in the streets of Paris. The offence that the veil may cause to other passerby does not fall under any protected convention rights. There is no right not to be insulted. There is no right not to be exposed to beliefs that are different from one's own. If common values were therefore, according to me, rightly upheld in Liddell, they wrongly stifled individual rights to religious expression in SAS. As was elegantly put, freedom of expression, and one may add freedom of religion, cannot be left to strive under the dictates of governmental fear of public sensitivities. Thank you.
Thank you very much. An erudite and practical exposition. Can I radicalize your argument a little bit on the burqa? You were clearly saying that you didn't agree with the ban of the burqa in France. Can I give you a situation where, for example, a female doctor wearing the burqa in my hospital would be looking after a critically ill patient, and it's meant to be a radical situation. How do you there balance the rights of the patient for appropriate care under the state and the rights of that doctor to wear the burqa?
Well, I think the burqa ban in Paris was an easy example because there was no rights, no other conflicting rights other than the feelings of discomfort of the majority. So in that case, it was quite clear, according to me, that the individual rights to wear the burqa should prevail. In other situations, I would be it's a case-by-case approach, but I think the rights of the patient would prevail.
Okay, thank you very much. This person here.
Thanks for a very interesting point of view. In the case of the burqa ban, you're very clear that you don't ascribe any value to social norms or to the offence of others.
In law, yeah.
In law,
yeah.
Can I ask, obviously in this country we don't have a burqa ban, but we do have laws in terms of how you dress, for instance, against nudity. Yeah. It's not something that particularly appeals to me, but there are people, as a particular individual, I believe. I'm not going to take anything off. There's a particular individual, I believe, who for years has campaigned for the right for himself to walk around naked, and has even spent time in prison, I believe, to do that. Yeah. What would you argue? Because in that case, the only argument against him doing that is social norms and possible offence to other people. Would the same arguments apply, that that's also an unlawful restriction?
You've picked the difficult case. So it's probably the only example where there's an analogy. I think at a European level, I think nudity is a case where a looser human rights proportionality test could be enforced, because there is, and a wider margin of appreciation could be granted to member states, because without getting too technical, there is European consensus about banning nudity. And when there is European consensus on a particular practice, that's an argument for thinking that this position is legitimate. So that's partly answers, that's a contradiction. The whole point of law is where the majority... I agree, I agree, but that's for a different reason. That's because the European Court of Human Rights is not a legislature, and because it has to give some discretion in some instances to national states. But at national level, I think that social conventions should never be enough. And nudity is the difficult case, yes. In theory, because in practice, it's very rare that it's being challenged. And actually, even in nudity, there is accommodation. You have beaches, well, there are many beaches in France where you can be completely naked. In a way, the burqa ban went beyond existing prohibition. It would be a mistake to think that before the burqa ban, wearing the burqa in France was always allowed. It would have been inconceivable to wear it in a hospital. It would have been inconceivable to wear it at security checks or when picking up children from school. So it's the extension to the whole of the public space, which I really criticize.
Thank you. Thank you.
Thank you. As you may imagine, I did not agree with a single word you said. As
always.
So let's not rehearse that again. I just wanted to point out a slight error in your opening remarks about prayer at council meetings. It was not a challenge to prayers in council meetings. If they want to pray at council meetings, they can. Nobody objected to that. What the problem was, the summons to council members included the invitation to start with prayers.
Yes.
So that was the only problem. If people want to pray, they can. There's never been any objection to that. So
no, I agree. Yeah.
So, okay.
Yeah.
So let me give you another example of. I'm not going to go through the contradictions in your statement, but recently in Islington, there was a sauna, and in saunas people are usually naked.
Sorry?
A sauna.
A sauna.
People are usually naked. There's a new stipulation that people in saunas have to be clothed in order not to offend people of a particular community. The community was not actually named. But I would like your response to this.
So my response to the obligation to wear clothes in sauna so as not to offend. But I think it's the whole argument about not translating into law offences. I think that it doesn't mean that we can't find other reasons for legal intervention, but the only reason cannot be that a given practice is offensive to a certain community. First, it will be impossible to respect everyone's expectations because they are conflicting, and because, as I've said many times, I don't think there's any inherent legitimacy in aligning laws onto social expectations.
Can we keep questions very short, please?
There are situations where children will be involved, where teachers and children don't have much of a voice in the European courts, though things are decided for them. And would you consider that the reverse should happen in countries where women have to wear the burqa and things are imposed like violence and FGMs, and you can't just let fly because, and what about the coercion of women? I know a lot of women who are coerced into wearing them and coerced into saying that they want to wear it themselves. I wonder if you could respond to that.
Well, of course, if there is coercion, but the European Court of Human Rights will only be involved in cases stemming from Council of Europe. If there's coercion, of course, then it should be prohibited. But empirical research has shown that in the case of France, women who decided to wear the burqa were usually divorced and not coerced by their fathers or husbands.
Could you amplify, please, your theories, your thoughts on the second case? Why it seemed to me you were saying that it was not acceptable that the rights of the minority person, the lady who wished not to officiate, should not be allowed to have a. I mean, why could there not be a compromise where? Such as that was proposed. Particularly, as it seems to be the burqa case is saying just precisely that it is possible for people to wear a burqa, providing it doesn't in some way seriously upset the social balance, etc.
Thank you. Next, the lady.
Shall I answer straight away? I think that I'm not against having common values. And I think that if we go down the route of systematic accommodation, we will maybe lose a sense of national cohesion. And I think that there are instances where a state may legitimately, she was a public agent, a state may legitimately want to have common values prevail over individual rights.
Thank you. That lady there, then the gentleman in the red hat.
So you disagreed with the ruling on the French ban because it was based on living together, right?
Yes.
But would you agree that the burqa is actually, it's a uniform of religious fundamentalism, which is about inequalities. So it's actually, a political as well as a religious symbol, and that had the ruling therefore been made because this actually threatens women's rights and equalities, would you have agreed with that?
Well, so the problem that if it had been proven that the women in question were coerced and that there was a problem of inequality between men and women, yes, but I think it's very difficult to ascribe like this one unilateral meaning on a religious symbol. The same for cartoons. It's very difficult to say that it is the position of the audience and the way they react to a symbol that needs to prevail. The problem was that actually evidence suggested that on the contrary, those women were not coerced into wearing the burqa. So the argument of equality is very difficult to make.
Thank you. Recently in the United Kingdom, a vicar bought a new car. and she put some Christian stickers on it saying Jesus is Lord or something like that. And the insurance company refused to insure her. Discuss.
Really? Because of a fear of retaliation, or I'm not sure why insurance companies. Well, I don't think it's legitimate, because I don't think that fear of violence should dictate.
Is that discrimination? Sure.
Yeah. Well, I had difficulties getting car insurance as a French person, so.
Returning to the Liddell case, is there not an analogous situation whereby doctors, you would know this, doctors, particular individual doctors, are allowed to opt out of performing abortions if they have moral objections to it, and this seems to be handled without having recourse to law. It's doesn't it?
Well, it's in the legislation. And that's the difference.
Is it in the legislation?
Yes, and that's the difference. I think that when in Parliament it has been discussed and an exemption has been granted after a national debate, that it's fine. But to then have challenges brought in courts questioning every single decision based on religious request is much more threatening for social consensus. Had the question been discussed and the exemption agreed in legislation through Parliament, yes, but it wasn't the case.
Right, but that's how it gets to be discussed in Parliament, isn't it? By somebody making an individual making an objection. That's how it works.
But it doesn't mean that the judge should grant the request.
No, okay.
Thank you very much. Well, that was really a wonderful discussion following a wonderful lecture. What it underlined to me, the thing is far more complex than I thought it was, and it's a question of balancing how we can live together. Thank you very much indeed.
Thank you.